Welcome. Professor Marc DeGirolami will be formally installed as the inaugural St. John Henry Newman Professor of Law on Monday, November 4th. It is customary for a professor holding an endowed chair to give a lecture associated with the installation. This morning's lecture is that occasion, and it is my welcome task to introduce my colleague and friend with whom I direct the Center for Law and the Human Person here at the Catholic University of America, Columbus School of Law. I would like to begin with a prayer. Because there are so many students present, I'd like to offer as a prayer a well-known reflection by St. John Henry Newman about vocation and mission. If you aren't familiar with it, it is at once beautiful and encouraging and consoling, especially as you contemplate the meaning or struggle to discover the meaning embedded in your studies, your work, your relationships, and your sufferings. So this is the prayer. God has created me to do him some definite service. He has committed some work to me which he has not committed to another. I have my mission. I may never know it in this life, but I shall be told it in the next. I am a link in a chain, a bond of connection between persons. He has not created me for naught. I shall do good. I shall do his work. I shall be an angel of peace, a preacher of truth in my own place, while not intending it if I do but keep his commandments. Therefore, I will trust him. Whatever I am, I can never be thrown away. If I am in sickness, my sickness may serve him. In perplexity, my perplexity may serve him. If I am in sorrow, my sorrow may serve him. He does nothing in vain. He knows what he is about. He may take away my friends. He may throw me among strangers. He may make me feel desolate, make my spirit sink, hide my future from me. Still, he knows what he is about. This prayerful reflection on the unique and divinely imagined mission crafted for each person is fitting for my task to introduce Professor DeGirolami. I will dispense with his formal biography and prodigious list of accomplishments which you can read in the conference brochure, and instead emphasize that although he may not know the entirety of his commission in God's service, and I do hope that he doesn't feel that he's been taken away from friends and thrown among strangers here at Catholic Law. But we do know, and he surely knows, that he has been entrusted with a definite service here at Catholic Law. St. John Henry Newman identified several qualities in that passage that are common to the service of God, albeit expressed uniquely in each person's definite vocation. I will mention three. First, we are called to serve God in relationship, to be a bond of connection between persons and even a link among generations. In the triune God, in a living church, in a flourishing university, cor ad cor loquitur. Second, that the vitality of one's public witness to the truth is intimately connected to one's moral and religious character. The first of these two qualities are abundantly evident in Professor DeGirolami's erudite and humane scholarship, especially his ongoing project on tradition, made up of those perfectly imperfect, concrete but enduring practices that communicate what it means to be authentically human and which have the capacity both to teach law and to protect law by keeping it moored in reality. These qualities are also evident in the warmth of his solicitude for his students, to whom he demonstrates the cultivation and integration of what Professor Martin described last night of Sophia and phronesis, of professional competence and Christian wisdom. These qualities are evident in his generous friendships, animated by his faith, whether those down the hall, across the miles, or even through the centuries. Newman describes love and friendship as practiced by, quote, by bearing with their infirmities, by overcoming their occasional waywardness by kindness, by dwelling on their excellences and trying to copy them. Thus it is, he said, that we form in our hearts that root of charity, which though small at first, may, like the mustard seed, at last even overshadow the earth. The quote here is referring to Professor DeGirolami's patience and bearing with our waywardness, not us bearing with his. But as a new and I hope lasting friend of Marc's, I can witness to this gracious quality of his friendship. So I mentioned a third quality, and I'll end with this. There's a third quality observable in serving a crucified God, and that is that Newman highlights that God's will for us may be accomplished as much, if not more, through our sufferings as through our accomplishments. May it not be so here, but at a conference devoted to Newman, we would be remiss not to notice it. Newman knew this better than most, as he experienced many hardships and setbacks and disappointments in his vocation. So much so that he quipped, quote, "The rule of God's providence is that we should succeed by failure." May the qualities outlined by Newman about vocation be prophetic exhortations to Professor DeGirolami and to each of us as he perseveres in his unique mission, whatever may come, and strives to continue to do good work, to do God's work here at Catholic Law. So please join me in welcoming Marc DeGirolami to deliver the St. John Henry Newman Professor of Law Chair Lecture entitled, "The Very Idea of Tradition in the Law." Thank you.
Well, thank you very much, Elizabeth, for that extremely generous introduction. It's a pleasure to be with you on the occasion of this conference to honor the polymath and Prince of the Church, St. John Henry Newman. It's customary in lectures of this kind to pontificate and make grand pronouncements to other scholars in one's field, and I will do some pontificating, but I have a different audience in mind. I want to talk to students, friends, colleagues in other areas, and generally interested people about tradition, to those who might find in tradition something appealing, enchanting, and attractive. I want to ask why so many Americans, and increasingly and interestingly, so many young Americans, are drawn to or even wish to return, here the U is sometimes spelled with a Latin V, to tradition. How can we account for the worth of tradition? How might we understand its persistent allure in our lives and in our law today? For the appeal to tradition, as the students of our own law review have recently observed, has become something of a lingua franca in constitutional law. The Supreme Court seems to have discovered tradition's many attractions. But tradition is a hard word. It gets lumped together with other things. History and tradition, for example, or text and tradition, or history analogy and tradition, or some other such pastiche, with the result that tradition itself becomes obscured or even erased. But if tradition really is a legal lingua franca, a language meant to bridge cultural difference or make communication possible for a scattered people, we will need to know a good deal more about what it might be. Hence my subject, the very idea of tradition, which may be taken in two senses. First, as scandalized remonstration, as in the very idea, he told me I look like I've been eating well. Or for my students, the very idea that I have to suffer through this tedious lecture. Second, the second sense, as the earnest attempt to get at the truth of a matter, as in I want to get at the very idea of the reasonable person in criminal law, or the Christian doctrine of the Trinity, or the nature of love. Let me begin with a scandalous sense. To say in America today that we are bound by tradition, let alone improved or ennobled by it, is to flirt with taboo. Many of us want to believe, perhaps we really do believe, that we are entirely self-moved and self-motivated agents, unconstrained by our past, and at perfect liberty to choose our own destinies. It matters not how straight the gate, how charged with punishments the scroll. I am the master of my fate. I am the captain of my soul. William Ernest Henley's poem is something of a modern American anthem. It may then seem surprising or even bizarre to say that in our world, tradition exerts a powerful influence on us. So in this lecture, I will reflect on four matters. First, and to create the conditions for a somewhat favorable hearing, on tradition in ordinary life. Second, on tradition in law, and constitutional law especially. Third, on the value or worth of tradition, where I will extremely tentatively and speculatively explore an analogy between constitutional law and Christianity. Fourth, and drawing insight from some of Cardinal Newman's political writing on the relationship of tradition and change. So first, to begin to see how tradition maintains claims on us, it may be helpful to begin with something commonplace and familiar: food. Here we will notice the very idea of tradition everywhere. Consider a well-known Italian restaurant in New York City, not a destination widely regarded as the beating heart of traditionality. Il Gattopardo, the leopard, after the novel by the Sicilian nobleman Giuseppe Tomasi di Lampedusa. Though the restaurant itself is just a generation old, it proclaims that it maintains the tradition of Italian culture. Quoting the book's most famous line, the restaurant says, "If we want things to stay as they are, they will have to change." Perhaps in an echo of Cardinal Newman, who said of an idea, as Professor Martin mentioned, it changes with them to remain the same. New York follows in Italy's wake. Enjoyed that line. There is a common Italian expression, un ristorante tipico, which means a restaurant of a locality or a region that specializes in the ancient recipes and methods that endure and that typify the best of the spirit of the people of that place, the traditional manner of dining. Or reflect on a story a few years back about an uncanny spike in demand for chartreuse, a green liqueur made for centuries by Carthusian monks. The recipe is known only to them based on a secret manuscript given to them in 1605, which was itself derived, so the lore goes, from a medieval alchemist's brew for an elixir for long life. During the COVID-19 years, when cocktail creation as well as collective thirstiness were trending upward, the monks stubbornly declined to expand production in response to these market pressures. This would have, they believed, interfered with their life of prayer and solitude. The spirit, in consequence, became even more desirable. The ancientry of the method, the mystery of the ingredients, the handcrafted care with which the cordial is made, its sheer endurance across the centuries, all of these seem somehow to hold chartreuse's aspiring drinkers spellbound. Even today, green chartreuse remains as expensive and as difficult to acquire. Many other similar stories could be told, but are these anecdotes about merely inessential matters? I do not think so. What could be more essential, more elemental, than how we eat, how we think about our food? It was the eminent Ancien Régime French lawyer and judge, the author of The Physiology of Taste, Jean-Antoine Brillat-Savarin, who once said, "Tell me what you eat, and I will tell you who you are." In fact, one sees appeals to tradition in cuisine routinely, in cooking, in fine dining, in the fashioning of specialty foods and spirits, and in far less bespoke and more everyday settings, in the kitchen and the cellar and the dairy and the distillery and the little grocery and the bodega. To be traditional is often thought desirable and admirable. We see in this a longing for access and connection to prior worlds by respecting and perfecting the recipes of old, those that endure, those that are correct and pure and perfect. Other areas of ordinary human endeavor are like this too: singing and the playing of musical instruments, sports and other games, auto mechanics and repair, sailing or seamanship, drawing and painting, carpentry, the composition of poetry, the practice of learning how to write well, even the learning of a language. To engage in these activities is to submit oneself to a body of past and enduring standards of excellence, of quality, knowledge, expertise. Now to my second theme. What about law? It is also this way. In the common law, the body of law determined, some say discovered, others say made, in judicial decisions over long spans of time, tradition is a constant and subterranean force in the form of custom. Custom serves as a way to construct and transmit the legal past, looking back at it from the present. A lawyer or a judge approaching the law generally intends to carry on some lasting way of thinking or reasoning or doing into the present. So too with judging and law practice, which are often described as crafts. Judge Learned Hand, himself known as a judicial craftsman, once even likened the qualities of a judge to those of a cook. Into the composition of his dishes, Hand said, he adds so much of this or that element as will blend the whole into a compound delectable, or at any rate, tolerable, to the palates of his guests. The test of his success is the measure in which his craftsman's skill meets with general acceptance. Law practice is like this too. Lawyers learn the traditions and the craft of letters, motions and memoranda, briefs, discovery documents, contracts, wills, trusts, legal codes, oral argument, registration statements for the sale of securities, bits and scraps of official legal counsel, all the while applying what the late legal scholar Frederick Schauer has called distinctive techniques of reasoning. These all have a shape and a form that must not deviate from the just so formalities that have always made such artifacts what they are. In constitutional law, traditions are made up of enduring political practices which the court has seen fit to give presumptive authority as determinants of the law of the Constitution. Endurance is itself made up of the age of a practice, its longevity, and the density of its adoption across the nation. Traditions are ongoing sets of arguments representing the views of those situated within these practices, developing over time concerning excellence in it, and what I have before called traditionalism in constitutional law gives primacy to enduring political practices for several reasons. First, because constitutional justice, the justice referred to in the preamble of the Constitution, is in part a collection of goods internal to the enduring practices that shape our constitutional law, and not merely the external result of those practices. Constitutional justice is often disclosed to us through lives of political practice and in the social and political institutions that structure those practices. There are many features of constitutional justice that cannot be accessed or specified apart from the practices that determine our constitutional law. The complex of rules determining, for example, the just use of deadly self-defensive force with a firearm over time and geographic space, or the laws and liberties that shape the proper exercise of legislative prayer or the regulation of signage in the physical spaces where people live and work together. These are all the traditions within which people acquire certain political excellences or virtues, and through which those virtues are manifested in community. Now, this is not to say that constitutional justice is a matter of popular referendum or of mindless, repetitive behavior. It is not. But it is also not a matter of abstract thinking alone. Traditionalists in constitutional law believe that thinking and doing should be united. Thinking well about the worth of a political practice in constitutional law is bound up with engaging in the practice of constitutional government. And if thinking about the worth of the practice cannot be extricated from the practice itself, then getting a true grasp on the world depends upon our doing things in it, regulating behavior, governing, participating politically, and not only thinking about the things that we or others do. Without that union, we fail to account for embodiment and purposiveness, for those features of actual thinkers who are always in particular situations. Second, we the people are sovereign in our polity. The people are supposed to be, as the philosopher Matthew Crawford once put it, masters of their own stuff, shepherds and custodians of their own government, seeking political excellence as they see it. Why then do increasing numbers of Americans feel alienated and disaffected from their institutions of government and their Constitution? How is it that the deformation of our politics has made Americans particularly skeptical about their own Constitution and the possibility of excellence in constitutional governance? The problem involves a central feature of Republican agency. The people mature in their constitutional excellence through the experience of their practices, and they derive cognition of excellence from sources other than abstracted, universal, reflective reason. When constitutional theorists and judges refuse to incorporate or account for the people's practices, they strip the people of that agency. They prop themselves up as the constitutional scientific management over the menial workers, as the meaning of constitutional work becomes more remote from the worker who does it. The people are in consequence alienated from their Constitution. They feel no affection for it. They come not to love it. But why? Why? Moving to my third theme, what is the value or worth of tradition? I propose, in the spirit of this conference, and yet with no small degree of trepidation, to reflect on this problem comparatively in Christian theology and constitutional law. But first, I have two rather sizable cautions to communicate. First, I am not a theologian. There are theologians together with us today in this room, and I will do my best not to induce the excessive raising of their eyebrows, but I may not succeed. And this is a far more tentative and exploratory portion of my lecture. Second, the analogy between Christian theology and constitutional law will be, at best, highly imperfect. It will have limits. While both Christian and constitutional texts are venerable, even venerated, Christian scripture is meant to be prayed and believed. American scripture, as the historian Pauline Kael once called the Declaration of Independence, is not meant to be prayed at all. If it is meant to be believed, the beliefs are of an entirely different order than the truths of Christianity. Yet with the decline of belief in the authority of Christian scripture, secular scripture filled a void. For some, the 10 Commandments of the Bill of Rights may even substitute for the 10 Commandments of the Decalogue. A polity with no national church will find its civil religion somewhere. Still, drawing on, yet disagreeing with, some observations by the Christian historian Yaroslav Pelikan, I want first to make the analogy. You may all then apprise me of its infelicity. I'm not the first to notice it. In 1959, Edward Corwin, one-time McCormick professor of jurisprudence at Princeton, fired off this broadside. The Reformation superseded an infallible pope with an infallible Bible. The American Revolution replaced the sway of a king with that of a document. I hope to do a little bit better than that. In both Christian theology and American constitutionalism, a communal tradition of belief and practice precedes a foundational, ancient, and, in some various sense, inspired text. The community of Christians believed in Jesus Christ and practiced accordingly. We, the people, believed in and practiced certain arts of good government. In time, membership in the community was partly constituted by the text. The text was incorporated into the tradition. The scriptures alone did not bring the Christian tradition into being. The tradition in the church is the interpretive key to the scriptures. The constitutional text did not bring the American people into being. We, the people, came before the Constitution, and we ordained and established it, presupposing a tradition of excellence in government. A constitution in Aristotle's sense, a polity, a regime that is the text's interpretive key. The text's authoritative status is partly grounded on the assumption that the tradition of the text's understanding may be applied by future practitioners to the considerably changed circumstances of later times, many of which the writers who originally wrote the document could not themselves envision. Enduring practices disclose the law, the doctrine of the document, and glue together the consecutive generations of the respective communities. The text itself elicits painstaking, highly elaborate, often Byzantine interpretation and reinterpretation. But it does not specify how its meaning or law must be derived. A church council, or Roman rota, or Sanhedrin, or Supreme Court submits itself to this ancient authority to unravel the text's meaning and law today. These efforts result in doctrine, which include techniques for coping with inner contradictions and change within a supposedly homogeneous body of learning. Indeed, it is to the development of doctrine, far more than to formal amendment, that the community looks for guidance as to change that nevertheless is supposed to preserve continuity. We might ask several questions at this point. One is explanatory. How do we account for these similarities? Have constitutionalists consciously adopted the techniques that Christian expositors had used in previous centuries? Or have interpreters in these different spheres independently arrived at the same kinds of questions and techniques? A second question might concern meaning. How is deriving meaning in this way possible? We say of some passage, a recondite parable in the Gospel of Matthew, or a difficult tract of St. Paul's letter to the Romans, or the 14th Amendment's due process clause. The people who wrote these words never imagined that they meant X. And the uninitiated reader today would be startled to learn that they mean X, and yet still the passage means X. But what does it mean to say that the text means X in those circumstances? A third question is anthropological. What sort of human need does the drive to rely on tradition respond to? We need not do things in this fashion. Human beings could live their lives in a resolutely forward-looking, pragmatic way, and some constitutional theorists have even recommended that course. But for some reason, Christians and citizens of the American Constitutional Republic have chosen another path. We live not, or not only, on the basis of what can be, but instead bonding ourselves to what has been. How do we make sense of this compulsive need to cherish the reconstructed past. One of this trio only will be sufficient for today. Exegetical commonalities and the meaning of meaning I will leave to the side. But I have something to say about people and why they seem ineffably drawn to tradition. One answer might be called the response from utility. Tradition serves our interests and needs because, through a process of the survival of the fittest, and in the sifting of many minds, and in the refining fires of the test of time, the best ideas and practices are the ones that win out or last. The value of tradition is that it cautions us to be epistemically humble about our present capacities. It punctures the pretensions of an overconfident rationalism to see here and now what is best for us. A second answer concerns identity. We value Christian tradition and constitutional tradition because it's ours, because it is what constitutes us as individuals and communities. Tradition endows us with a stable sense of ourselves, and this is necessary for us psychologically and culturally. Without our traditions, we are nobody, and we are nowhere. Our traditions give us existence, and existence we lose if we depart from them, at least too dramatically. Here's a third answer that incorporates the other two while adding something of its own. The response from excellence. Traditions are the way human beings manifest an important part of what is excellent about us. This is, as far as I can make out, what those who find traditions self-evidently, magnetically compelling in cuisine, architecture, sports, poetry, music, writing, the many uses of language, university life and learning, law, and perhaps in part, Christianity, have in mind and are ineffably drawn toward. They are looking for a union with and a continuity of their own practices with something more than or greater than their individual lives, choices, and achievements, with something lasting and true. In the Christian tradition, they are looking for the Logos, for the peace of God that surpasses all understanding. St. Paul tells us in the first letter to the Corinthians, "That which I received from the Lord I passed on to you," and he enjoins us in the second letter to Timothy to guard the good deposit entrusted to you. Guard it with the help of the Holy Spirit who lives in us. In the 5th century, Pope Leo I put it this way: "A man who has not the most elementary understanding even of the Creed itself can have learned nothing from the sacred texts of the New and Old Testaments. At least he should have listened carefully and accepted the common and undivided creed by which the whole body of the faithful confess." The Emperor Justinian, about a century later, said this: "This is the sound tradition that we preserve, which we have received from the Holy Fathers. This we would take as our companion during our life, that we might be made citizens of heaven." Or here, more than a millennium later, from Pope Paul VI's dogmatic Constitution Dei Verbum: "Sacred tradition and sacred scripture form one sacred deposit of the Word of God committed to the Church. Holding fast to this deposit, the entire holy people, united with their shepherds, remain always steadfast in the teaching of the apostles, in the common life, in the breaking of the bread, and in prayers, so that holding to, practicing, and professing the heritage of the faith, it becomes on the part of the bishops and faithful a single common effort." What does tradition offer? Something to render a person's own existence coherent and continuous with the lives of admired progenitors and hoped-for progeny, to live, as Edmund Burke put it, in the presence of canonized forefathers, and to walk amid the gallery of portraits of illustrating ancestors, but also, I would add, to take one's own place in that mighty portico in the view of those that are to walk in it afterward. True, traditions are useful to us and constitutive of our identity, but at their best, they are more than that. The notion of human excellence depends upon transcendent concepts of valuation that extend in the before and after time of a person's own life. Human beings value what they do on the generally tacit premise that human excellence existed before they were born and will exist long after they die. Without that assumption, they would think of achievement in human affairs very differently than they actually do, if they thought of it at all. For the standards of achievement, as Alistair MacIntyre once put it, within any craft are justified historically, and what are actually produced as the best judgments or actions or objects so far are judged so because they stand in some determinate relationship to the finally perfected work. I believe that this answer from human excellence also can explain what is now occurring in the invocation of tradition as a lingua franca in American constitutional law. Even as the very concept of constitutionalism is inherently preservative and custodial, connoting that which is legally essential and enduring, treatments of the meaning and legal content of the Constitution relentlessly slight the gravitational attractions of tradition. The notion of doing constitutional law well by doing what has been done before is not rejected. It is generally not thought of. But if one looks only at the changes and disruptions in our constitutional order, the result will be a failure to do justice to that order, which also tells a tale of tradition. Note again an analogy that we might run backward to theology. Irenaeus and Origen in the 2nd century A.D. appealed to the authority of the people as arbiters of Christian doctrine. We the people, as the foundation of the constitutional order, finds a kind of parallel, an imperfect one, of course, in the theological notion of the sensus fidelium, which, as Cardinal Newman put it, testifies to the apostolic tradition and affirms, quote, the role of the laity as bearers of authentic Catholic tradition, close quote. Both domains have also generated a thick scholarly incrustation that has created a great escarpment between the realms of the academy and those of common practice. The result of this academification is the emergence of two normative systems, one contained in the tradition, the other found in the creeds, theological and constitutional, of the professors, but not of the church and not of the people. A final matter, what about change? What about bad traditions? A common criticism of traditionalism in constitutional law, and in general, is that, as Chief Justice Roberts recently put it, it traps what exists in amber, or that it is brittle and incapable of development. We want growth, to be sure, but we want growth of the right kind. We want our children to grow strong and well, but cancers grow too. It is certainly true that not all traditions are worth preserving. Slavery might be described as an enduring practice in this country. Segregation of the races and railway cars and schools might as well. Some of these practices were expressly supported by the court on the basis that they comported with the traditions of the people. We have come to see that these practices should be rejected, and we have rightly done so by formal amendment or other mechanism of change. Does this mean that our traditions must fail us? I would not say so. What it shows is that we are fallible, and that we should therefore expect some fallibility in our traditions of constitutional law, and not the kind of fallibility that can be interpreted away through one more clever argument about what the text really means, or what a disembodied principle that has to this point been misunderstood actually demands. To see the fallibility of some of our traditions is not to repudiate all of them, and it is a mistake, or else a piece of cynicism, to take our worst moments as a kind of warped House of Mirrors reflection of our constitutional polity. In fact, the capacity to see the fallibility in some of our traditions presupposes that we understand what they are, especially if the people are to cast off or abandon a tradition. They will not know why they do so. They will not know to do so unless they have first understood it. Practice and cognition go together here as well. Here again, we might recur to a theological analog. We have heard yesterday from Professor Martin, and we will be hearing from distinguished guests today about Cardinal Newman's 7 tests for, as he later called them, notes on distinguishing authentic developments of doctrine from corruptions in his essay on the development of Christian doctrine. In fact, Newman several times expressly analogizes between theology and jurisprudence. In my own estimation, Newman's notes are valuable, but taken alone, they are more in the nature of rules of thumb, or what he himself later calls tokens, than rules. Consider, for example, the second note, preservation of principle. Newman writes that because doctrines expand variously according to the mind, individual or social, into which they are received, the life of doctrines may be said to consist in the law or principle which they embody. Newman may be right about this. Probably he is right. But there's a difficulty that will confront anyone who tries to use Newman's notes as rules for how tradition should or should not develop. The notes are conclusions about what to argue about rather than rules that could help resolve such arguments. Preservation of principle is a familiar concept in constitutional law, but constitutional lawyers will understand what asserting it can, and more importantly, cannot do. For any live constitutional dispute, affirmative action, sexual liberty, federalism, religious freedom, and so on, it is of only modest help to say that we should adopt an interpretation that is continuous with principles discernible in the text and tradition. Most people already know that. Most people take it for granted. The dispute will be about which among the clashing principles extractable from the text and tradition best succeeds in maintaining such continuity. Can we nevertheless mine Cardinal Newman's work for some assistance? I believe so, if we look to some of his more political and legal, or in fact, constitutional writing. He takes a view of the development as to these questions that highlights the centrality of enduring political practice. Before getting to the notes, Newman describes what he calls political change, of which he thinks changes in the Constitution a variety. In these, often the intellectual process is detached from the practical, I'm quoting Newman here, and posterior to it. A new theory is needed for the constitutional lawyer in order to reconcile the existing political state of things with the just claims of the state. For Newman, the pressure for legal change comes from practice first, and only later is the ratiocinated theory devised to account for it. Legal change, Newman also describes as historical change. Quote, the gradual formation of opinion concerning persons, facts, and events. Some authoritative accounts die away, others gain a footing and are ultimately received as truths. Courts of law, parliamentary proceedings are in this day the instruments of such development. Accordingly, the poet makes truth the daughter of time. Close quote. Again, we see Newman here quoting Francis Bacon, the outstanding 16th century English lawyer, judge, and scholar, and great rival of Sir Edward Coke, discussing legal change as both motivating and motivated by custom and popular acceptance or ratification. But Newman's most acute observations on law appear in a series of 8 letters written under the pseudonym Catholicus during the Crimean War concerning English constitutionalism. These are collected under the title, Who is to Blame? Here is a bit from the 3rd letter. Quote, it is then no paradox to say that every state has in some sense a constitution, that is, a set of traditions depending not on formal enactment, but on national acceptance in one way or other restrictive of the ruler's power, though in one country more scientifically developed than another, or more distinctly recognized, or more skillfully and fully adapted to their end, close quote. Or this from the seventh letter, quote, "It is inexpedient to suffer the tradition of law to flow separate from that of popular feeling, whereas there ought to be a continual influx of the national mind into the judicial conscience. And unless there was this careful adjustment between law and politics, the standards of right and wrong set up at Westminster would diverge from those received by the community at large, and the nation might someday find itself condemned and baffled by its own supreme oracle of truth." Newman's conception of legal development depends, it seems to me, upon his view that within the ambit of reason permitted by the natural law, an important qualifier, the political and historical problems of constitutionalism lie within the space of what St. Thomas Aquinas called determinatio, the specification or disclosure of the political ends of justice pursued through the enduring customs and practices of the people, that is, through what in our constitutional law is tradition. In the last of these letters, Newman draws a parallel between constitutions of healthy physical bodies and healthy polities. I take some small inspiration that his central metaphor is, to end where I began, about food. Quote, "As in our own persons, one by one we consult for our particular constitution of mind and body and avoid efforts and aims, modes of exercise and diet which are unsuitable to it, so in like manner those who appreciate the British Constitution aright will show their satisfaction at what it does well, resignation as to what it cannot do, and prudence in steering clear of those problems which are difficult or dangerous in respect to it." Close quote. There are those who might say that for us in America today, this is all inapt and ill-suited. After all, we have a written document. We are exceptional in our constitutionalism, having made the world anew. But Newman had the greater insight. Constitutions are meant to sustain. They are meant to endure. They are meant to assist human bodies and their bodies politic in becoming as excellent as they can be. It is in the very idea of tradition, whether of life or of law, that we learn how to be good. Thank you. I'm happy to take some questions. From a theologian, no less. This is going to be trouble.
Marc, I just want to say that was a wonderful lecture, a really magnificent lecture. Now, I'm going to ask a question that that's not entirely, not directly related, but it's something that troubles me, and it's just something from within our situation. And so it's in the realm of theology, and then also to some degree in the church. The phrase traditionalist now has taken on a particular meaning. It's been claimed by, as I see it, it's been claimed by a party in the church, and perhaps because the appeal to tradition was for some period of time at least was seen as problematic, because of the reasons you gave as that you talked about. So I've been thinking about this and wondering, well, what do we do? Because as Catholics, we really cannot allow the word tradition to be claimed by a party. It must belong to the church as a whole. So I loved your lecture so much. I just wanted to see if you would reflect upon that just briefly.
I think it's an excellent question and an important one. It's actually one that Father Juan and I were discussing. He said, "Why are you using traditionalism and ism in here, and I'm a traditionalist. Why not just speak about tradition? And I see the importance of that. I am somewhat familiar with the reclamation that you're talking about, or with the sort of debates about what traditionalism is or who has captured that label. And I suppose one reason for the audience that I have in mind is to attempt to steer the word and the concept back, to channel it properly, because I don't want to abandon it, even as an ism. We can say that once you make it something an ism, that's bad, right? We used to say authority good, authoritarianism bad, yeah? But it seems to me other phrases in our law and culture go by an ism, and we don't think so. I know one word in the law that is a common one, and at least is not inherently, doesn't have that inherent sort of negative connotation, originalism. Originalism, no one thinks it's okay to be fine with origins, but once you're an originalist, oh, that's no good, right? But I do think that maybe just the word tradition, if we have a problem with traditionalism, it seems to me it's because we have a problem with tradition. And there are reasons for, in part good reasons, to be careful about traditions as the exclusive or the sort of unitary guide of our lives. But there are also important reasons to try to reclaim the label, to try to reclaim the concept as a good and right concept, and a necessary one, an important one, for certainly in the field that I write in, for the sustaining of the American polity, so that we the people have somewhere to go, to look to bond ourselves. That I think is a worthy project, and has suggested to me that I'm going to try at least to go the full ism.
Well, thank you for that wonderfully insightful and beautifully written lecture, Professor DeGirolami. I wanted to press you on the relationship between traditionalism and originalism. And I know that you're working on a book right now on tradition, available in bookstores, sometime soon for all of you to purchase.
Checks in the mail, Professor Alisea.
So you might not have this fully worked out yet, but you were very careful in your lecture to say that traditions are determinants of constitutional law. And I took you to be implicitly distinguishing between constitutional doctrines that are determined through tradition, and perhaps, on the other hand, the original meaning of the Constitution as a change in the law that occurs at a moment in time, but that is understood against a background of other traditions, right? So here's the question. It seems to me that you could be going one of two directions here. You could be distinguishing between the original meaning, which doesn't change, and constitutional doctrines that are necessary to kind of give flesh to the original meaning, where tradition determines that. But if that's your view, I wonder, why are we constitutionalizing those traditions instead of allowing them to just kind of change and not potentially just be frozen in time through Supreme Court decisions or something like that? On the other hand, you might be saying, not drawing the distinction that I think you're drawing, and saying, no, traditions actually can even change and supersede the original meaning. And if that's your view, then I think I'd want to know more about what justifies that. What justifies the idea that the people can change and supersede the original meaning through their ordinary practices, and how far does that go? Like, how far could they kind of supersede what the text says?
Yeah, thank you, Professor Alisea, and you've put your finger with your keen listening on a change that I have been thinking about with respect to traditionalism. So it was at one time, fairly recently, my view that traditions inform or determine the meaning of the text. And I have since, as a result of some interventions, including yours, come to see that I think the better view, and the one that I'm going to adopt, is the view that traditions determine the content of the law, not the meaning of the law. So that content can include things like doctrine or tests or whatever it might be that gives flesh to the meaning. So I'm going to be opting for the first of your two choices. Now, as to the horn of the sort of the dilemma that you pose for me, why do I think that we ought to constitutionalize traditions if they are filling out content rather than, I suppose, just sort of, well, I'm not quite sure what would be the alternative. So in other words, we need doctrine, we need law, the law of the Constitution. If you think about any particular amendment or provision of the Constitution, you think about the 11th Amendment, for example, involving state sovereignty, right? There are all kinds of doctrines, ideas that give flesh and content to help resolve cases, that determine the law of the 11th Amendment or of the First Amendment or whatever it might be, that don't go to the meaning of the words and that are necessary in order to make the constitutional railroad run, right? In order to get cases decided. And that, I think, is where the action in traditions are. Now, as to the relationship between originalism and traditionalism, it depends the kind of originalism you mean. Originalism is a big enough tent now that I think some originalists give some kind of evidentiary warrant as to traditions, even with respect to text. Some give it only with respect to law. Some give that kind of evidentiary power to no practices at all. So depending on which kind of originalist I'm dealing with, there may be more or less overlap, but the project, at least for me, will be to show how much action is in traditions in figuring out and understanding what the value, what the importance of our constitutional law is, and how we should sort of fall in love with it again.
Professor, that was brilliant. Thank you very much. I just wanted to question.
You get an A in criminal law.
Thanks. That sounds good to me. I wanted to take the question about traditionalism, traditionalist, and this maybe more divided notion of tradition, but apply it outside the church context into the American context, because it does seem to me, just to press the idea a little bit, we're kind of a unique situation in the United States. We're conserving a revolution. And so even the structure of the Declaration of Independence begins with this broad statement of rights that no one ever wrote down to begin a government before, but then it's followed by a series of specific indictments involving ways of living and practice. So it seems to me that, at least in our kind of society, tradition is kind of going up against a version of our tradition that is radical, right? And so there's going to be this competition that's always present. Is that right, or am I wrong about that?
I think it's a very acute point, and it may help to explain some of the just ingrained national resistance to tradition as a concept. I will say it's true that the Declaration was a kind of cry of radical liberty, but the Constitution is about pursuing the perfections of political union. And that seems to me a very different kind of document. It says so right in the preamble, right? In order to form a more perfect union, right? It talks about justice, right? It envisions, as all constitutions do, some kind of idea of what binds us and what lasts in a way that I don't think the Declaration does. So, with any populace, there are going to be, with any nation, There will be countervailing streams. There will be streams of freedom and sort of breaking away from the past. And there will also be streams of continuity and unity. And it's part of my project, at least, to try to suggest, don't forget about that second stuff. That second part is just as important, maybe in some ways more important than the first.
So let me add my robust compliments for this brilliant talk. I think that the proposition that custom precedes law is strong. And I think we see examples, two of which you noted, the sort of federal solution to slavery for the first half of the 19th century, and then segregation as a mode of social order for the next 100 years or so. Overlapping with that is contractual autonomy, which reflected another custom and practice. And most recently, in the second half of the 20th century and to date, really, personal autonomy. So I think that the hypothesis that law and politics are downstream of culture is right. Culture sort of capturing the common beliefs and traditions of a particular era. And you also rightly noted that we've got to weed out the bad ones, and we have for slavery and for segregation. And contractual autonomy, sort of, yes, and to the extent that it impeded legislative discretion and solutions. Personal autonomy, I think, continues to run pretty vigorously. But then you mentioned in the last part, subject to natural law. But that's not a footnote. And that, it seems to me that in that regard, it's the speculative order, knowing what is normative in nature, what is natural right, not a personal right, but natural right as justice, that has to cabin the force of tradition in defining law. And I guess I wonder how you would bring that into the legal dialogue.
Yeah. So it's a superb question, and I agree with the point that it makes at the end. It is. I speak about the virtues of practice, but those virtues don't exist in a world in which practice creates, defines, and is everything about them. They occur within an order of natural law. But the question will be, what is the sort of concrete question is, what is the scope of the deductions from natural law with respect to our positive law? How conclusively are those established, and how conclusively do they run through all of our positive law? And what is the space, what is the nature of the space within which traditions, practices operate? That, I think, is a difficult question. I don't have a sort of conclusive answer about that, but I do think that there are many areas, many parts of our law, not just our constitutional law. Friend Michael Moreland, wherever he is in the audience, has written about, say, the choice between a strict liability regime as opposed to a negligence regime. That choice, there's nothing in the natural law that commands that choice. And there are countless examples like that in our positive law. So what are the mechanisms by which we make that choice, bounded by the natural law? For me, the traditions, the practices of a people are the determinations of the natural law that specify, that make concrete what something like tort justice looks like in that context. But I agree with you. I agree with the premise of the question that it is not a footnote. I also think that the reasons, and this is something that I've been thinking about a little bit in response to some challenges of this kind, the question how we know to abandon a bad tradition must, it seems to me, and you even mentioned it yourself in talking about the sort of contractual kinds of traditions, must depend upon the adoption of other traditions, seeing that other ways of life and practices are preferable to the ones that we have been using, in a kind of combination or synthesis between reasoning and behaving in a certain way. But that's yet to do, Bill, I'm afraid. Good question. Terrific. Thank you, Elizabeth.
Thank you again, Professor. I'll continue with the flattery. Excellent job.
Thanks,
You
Doc.
didn't trip over your shoes. My question was regarding your discussion surrounding St. Thomas's notion of determinatio.
Yes.
Specifically, you said that that's kind of instantiated in our culture as tradition. I was just wondering if you could say something more about that and expand upon that notion.
Yeah, so the way that I think about this is that just as I was saying to Professor Rooney before, within the treatise on law, one can see these two different ways in which the natural law becomes part of positive law. One through deductions, conclusions that we can draw directly from the natural law. There's a reason that no civilized society permits the intentional killing of another human being without justification or excuse. Those are deductions, conclusions from the natural law, and no amount of practice or tradition can make it otherwise. But then there are situations in which the natural law isn't a participation in the human positive law in the same way, and in which choices are to be made. How are those choices to be made? Well, the conclusions of the natural law, the deductions, aren't going to determine how they get made. So they could be made, on the one hand, some people have suggested, on the basis of raw authority. The ruler makes a choice. The administrative agency tells you what to do. In my view, the better approach is to, at that point, take seriously what people do, how they behave, so as to give them ownership, to give them a vested stake in their law, to respect their choices, particularly, it seems to me, in a democracy, where the people are supposed to, in some sense, rule.